Welcome to the Supreme Court of the United Kingdom, where we're hearing the second day of the appeal in the case of Uber and Aslam and others. The case is concerned with the question whether drivers who drive for Uber are workers for the purposes of employment legislation conferring various rights on workers, or whether, as Uber argue, they are independent contractors who don't fall within the scope of the legislation. I'm hearing this appeal together with 6 of my colleagues, Lord Hodge, Lady Arden, Lord Kitchen, Lord Sales, Lord Hamblin, and Lord Leggett. As you can see, we're hearing the case remotely because of the COVID-19 restrictions. We're currently hearing submissions on behalf of 2 of the drivers, presented by Mr. Galbraith Martin, Queen's Counsel, and I'll invite him now to resume his submission.
My Lord, thank you very much and good morning. My Lord, I'm grateful to you for drawing our attention to the UBS case in which you sat in the Supreme Court. I am going to say a little about that case when I return in my submissions to look at my proposition that the Employment Tribunal was entitled to conclude that the claimants are workers for the purposes of the statutory definition, because I mentioned to your Lordship yesterday, and Mr. Siegel, who's made those cases available in the supplementary bundle, is going to focus on that as the main part of his submission. So I'll leave him to do most of the heavy lifting on that particular point. My Lords, I want to pick up where we left off yesterday, and I finished my submissions yesterday by saying that we are, in the circumstances of this case, clearly concerned with a relationship concerning work or relating to work or services, in the language of Lord Justice Aikins in the Court of Appeal in AutoCleanse. And I just want to take you to a couple of references to Uber's own documents, which make that point very well. The first in the main electronic bundle, please, is at page 521. This is a document dated the 19th of June 2015, and it was a document submitted by Uber as a response, you can see from the first line, to Transport for London's consultation on the future of private hire regulation in London, TfL being the statutory regulator for London. And I just want to take you to a couple of references on that first page. In the second paragraph, Uber's been embraced in an unprecedented fashion by London and Londoners. The basic facts speak for themselves. More than 1 million Londoners use Uber every month. I suspect that number is significantly higher now. They are served by over 15,000 drivers, many of whom rely on the platform for their livelihoods, which is the case for my clients. In the fourth paragraph down, third line down, reading from the end, thousands rely on us to make a living. But Uber itself recognises that the drivers drive for a living. There's another document that's also relevant on this point. It begins at 509 in the electronic bundle. And I want to take you particularly to this because you may recall yesterday Miss Rose made an observation about what she said was a comment made by an employee of Uber London's, that drivers are commission-based. They're paid 80% for every journey that they undertake. And she asked, perhaps rhetorically, why would you pay any heed to that? What relevance does that have? It's just an observation by an employee of Uber London. Well, in fact, we'll see that that observation is made in this document, which isn't a casual line from an Uber employee. It is, in fact, a document submitted by Uber London. So in the name of the company, you can pick that up. If you look at the last page, 512, you can see that it's signed by Uber London Limited, dated the 3rd of October 2014. And just to go back to the top of the document so that you see what it is, at the first paragraph, this supplementary evidence is offered by Uber London Limited further to evidence given to the GLA, that's the Greater London Authority, Transport Committee, by Joe Bertram, the General Manager of UK and Ireland, and Dominic Moxon-Trich, the Head of Public Policy Europe. Supplementary evidence builds on a prior submission for Uber filed with the clerks of the committee entitled GLA Transport Committee Investigation into Taxi and Private Vehicle Services in London. So it's not just a throwaway line, and the one in particular that refers to the payment of commission, you'll pick up at paragraph 6.2 on page 511 of that document. Uber drivers are commission-based and have no fixed fee charges, meaning they earn money from the very first journey. Drivers are paid a commission of 80% for every journey they take. That's not the only relevant passage in this document, though. If I can ask you to go back, please, to page 510. And under the heading Economic Impact at 5.1, Uber is providing job opportunities for people who had not previously considered working as a driver. At paragraph 5.2, Uber intends to work with previously unemployed people in various cities to provide assistance on how to become a licensed driver. And at 5.3, Uber's drivers usually earn significantly more than employees of traditional private hire companies. They, at the last line, take home more money. So, my lords, we say that is strong evidence that we are here concerned with a relationship concerning work or services. Uber London itself recognises that. My lord, yesterday I dealt with the statutory employment protection regime, but of course, and your lordships and my lady will be well aware, there's another regulatory regime that's also in play in this case. The regulatory regime created by the Private Hire Vehicles Act and regulations, and that also forms an important part of the backdrop to this case. The purpose of those regulations is, as Mr. Justice Easley stated in the TfL against Uber case, it's not in the bundle, but it's referred to in our written case at paragraph 123. The purpose of this regulatory regime is to protect the public. It is as set out by TfL in the forward to its guidance on the regulatory regime. This is the document, I don't need you to look at it, but at 2264 if you want the reference, to give the public confidence that they're dealing with a regulated professional organisation with honest drivers and safe vehicles. Moreover, it is the operator's responsibility to see that journeys booked with it are carried out safely and efficiently. In our submission, there must be a direct contractual relationship between Uber London and its drivers, because absent such a relationship, it's difficult, if not impossible, to see how Uber London can fulfil its statutory obligation to protect the public. To give just one example, Ms. Rose took you yesterday to Regulation 9 of the 2000 Private Hire Vehicles London regulations. If you need to, we can go to them again, but you'll recall that under Regulation 9, Uber London is required to establish and maintain a procedure for dealing with complaints. And under Regulation 14, it's required to keep a record of any investigation carried out and any action taken as a result. In our submission, Uber London can only investigate complaints against drivers and, in an appropriate case, take action against them if it's in a contractual relationship which gives them the power to do so. Of course, the power to investigate complaints and, if necessary, take action, whether under a performance management process or a disciplinary process, would be entirely unexceptional in an employment relationship. But the power of an agent to discipline its principal would be, to say the least, an extremely unusual feature of an agency relationship. Let's pick up on Miss Rose's reliance on the Gillam case at this point. The fundamental difference between Gillam and our case is that, as my Lord Reed pointed out yesterday, in Gillam, it was the statutory provisions which applied directly to the claimant in that case and constituted her relationship with the MOD. You can see that very clearly. It's a very short passage I'll take you to, just on page 1490, please, of the electronic bundle. And at paragraph 18, reading between letters H and J, towards the end of the line, the essential components of the relationship are derived from statute. and are not a matter of choice or negotiation between the parties. That was the essential basis on which the claimant lost on the normal test in the case of Gillam. That's very different, of course, from the situation here. The regulatory regime does not constitute the relationship between Uber London and its drivers. For that, we need to look elsewhere. We say the power derives from the contractual relationship found by the tribunal to exist in this case between Uber London and its drivers. And the Master of the Rolls and Lord Justice Bean were, of course, alive to this point in their judgment in the Court of Appeal. And if I can ask you just to turn to that very briefly, beginning at page 275 of the electronic bundle. And starting at paragraph 90, under the heading, the artificiality of the contractual documents. You'll see that there's a high degree of fiction, said the majority in the wording, whether of the partner terms or the new terms of the standard form agreement between UBV and each of the drivers. Uber London, despite being the PHV operator in London and therefore the only entity legally permitted to operate the business, is scarcely mentioned at all, even as an affiliate of UBV. And then if you go over the page to paragraph 91, the omission of Uber London from both versions of the standard terms is all the more striking because Uber London enforces a high degree of control over the drivers and for the most part does so quite understandably and properly in order to protect its position as PHV operator in London. It's difficult to see on what basis Uber London is entitled to act in this way other than pursuant to a contractual relationship between itself and each driver. We do not accept as realistic the argument that Uber London is merely acting as local enforcer for UBV as holder of the intellectual property in the app. Now, of course, Ms. Rose criticises that last sentence and says it's never been asserted that Uber London is merely acting as the local enforcer. But of course, that appears to be its case in relation to drivers' use of the app. The only contractual relationship, Uber says, between the parties is between drivers and UBV. Drivers have access to the app, and enforcing performance with the services agreement, as we'll see in due course, for example, drivers who they say do not accept a sufficient number of trips, is left to Uber London. So to that extent, it was Uber's case that Uber London was the local enforcer in relation to compliance with the services agreement. My Lords, we invite you to adopt the analysis of the majority set out clearly in paragraph 91 and to hold that in order for Uber London to discharge its statutory obligations under the regulatory regime, the tribunal was entitled to conclude that it was in a contractual relationship with drivers and will turn in due course to look at whether it properly characterised that as an employment relationship. But can I turn now to consider what we say is the right approach in cases of this kind? And I made the point in my opening remarks yesterday that the determination of the true relationship between Uber London and its drivers is a question of fact for the Employment Tribunal, requiring it to make an evaluative judgment based on all relevant evidence, which can include evidence that would not normally be admissible to construe a purely written agreement. I want to make good that proposition by reference to a couple of short passages in the Carmichael case, which begins at page 825 in the electronic bundle. My Lords, that case concerned guides who were employed on a casual, as required basis to take tourists around local power stations. They brought a claim that required them to establish they were employees not merely when working, but when not working. What's sometimes referred to as the gap between assignments, or to use more modern terminology, the gap between gigs. You can see that very clearly if you turn to page 827. And in the speech of Lord Irvine, his quick summary of the facts of the case at letter H. So the issue is narrow. The primary case advanced on behalf of Mrs. Leese and Mrs. Carmichael throughout has been that an exchange of correspondence between the parties in 1989 constituted a contract, and that contract was to be classified as a contract of employment. claim to particulars of terms of employment was not advanced on the basis that when they actually worked as guides, they did so under successive ad hoc contracts of employment. In other words, they were seeking to establish what in employment law terms is sometimes known as an overarching or an umbrella contract. When we look first then at the speech of Lord Irvine, with whom Lords Gough, Lords Jauncey and Lord Brown Wilkinson all agreed to 828 in the electronic bundle. The Employment Tribunal found against the claimants, upheld by the EAT, but the Court of Appeal reversed that decision and held that they were employees. The Industrial Tribunal, however, had held that their case, this is at letter F, found us on the rock of absence of mutuality. That is, when not working as guides, they were in no contractual relationship of any kind with the forerunner of national power, the CEGB. The Tribunal made this finding on the basis of the language of March 1989 documentation, the way in which it had been operated, and evidence of the parties as to how it had been understood. And Lord Irvine has this to say: for reasons I amplify later, this was, in my judgment, the correct approach. And then if I can take you to where he amplifies at page 830, letter B. In my judgment, it would be appropriate, only be appropriate, to determine the issue in these cases solely by reference to the documents in March 1989, if it appeared from their own terms and or from what the parties said or did then or subsequently, that they intended them to constitute an exclusive memorial of their relationship. The Industrial Tribunal must be taken to have decided that they were not so intended, but constituted one, albeit important, relevant source of material from which they were entitled to infer the parties' true intention, along with the other objective inferences which could reasonably be drawn from what the parties said and did in March 1989 and subsequently. And we say that is the approach that applies in our case in circumstances where there was no document that's purported to be an exclusive memorial of the relationship between Uber London and its drivers. I take you on to look at the speech of Lord Hoffman. There's a very interesting historical analysis of why we have the rule that construction of documents is a matter of law rather than a matter of fact, beginning on page 831 at letter E. You'll see Lord Hoffman identifies questions that are for the judge and questions that are for the jury. Questions which are for the judge fall into two categories, and included in the second category is the construction of documents in their natural and ordinary meaning. And Lord Hoffman goes on to explain why, which I needn't concern this court with at this stage. But at the top of page 832, you'll see, this is relevant for our purposes, the rule that the construction of documents is a question of law was well established when industrial tribunals were created and has been carried over into employment law. And it was that rule that the Court of Appeal had relied on in deciding that they could substitute their own view about whether the guides in this case were employees for the purposes of the legislation. But reading between letter B and C, Lord Hoffman has this to say: I think the Court of Appeal pushed the rule about the construction of documents too far. It applies in cases in which the parties intend all the terms of their contract, apart from any implied by law, to be contained in a document or documents. On the other hand, it does not apply when the intention of the parties objectively ascertained has to be gathered partly from documents, but also from oral exchanges and conduct. In the latter case, the terms of the contract are a question of fact. And of course, the question of whether the parties intended a document or documents to be the exclusive record of the terms of their agreement is also a question of fact. And then if I can just ask you to have a look at what in fact was taken into account in that case, because it mirrors some of the things taken into account by the Employment Tribunal in this case. So going into page 833 and at letter D, please. Lord Hoffman continues: the ascertainment of the terms of the agreement was a question of fact with which the Employment Appeal Tribunal were right not to interfere. The Tribunal took into account the language of the letters. And of course here, Uber criticises the Employment Tribunal for taking into account language used by Uber in its documentation. They also took into account the subsequent conduct of the parties, some of which pointed to employment, some of which did not, and the evidence of both the applicants as to what they understood their respective obligations to be. Both Lord Justice Ward and Lord Justice Chadwick said that was a mistake. But Lord Hoffman goes on, the austere rule would be orthodox doctrine in a case in which the terms of the contract have been reduced to writing. This is at letter F. I do not think that it applies in a case like the present. And then at the foot of that page, the evidence of a party as to what he understood to have been agreed is some evidence tending to show that those terms in an objective sense were agreed. 4 or 5 lines further on, evidence of subsequent conduct which would be inadmissible to construe a purely written document may be relevant on similar grounds, namely that it shows what the parties thought they had agreed. It may, of course, also be admissible for the same purpose as it would be if the contract had been in writing, namely to support an argument that the terms have been varied or enlarged to found an estoppel. My lord, that last sentence is relevant, of course. There, Lord Hoffman is recognising that matters such as language used by the parties, what they thought their rights and obligations to be, and evidence of subsequent conduct can be admissible even in circumstances where the parties have entered into a contract. He refers specifically to 2 circumstances in which it might be relevant. To support an argument that terms have been varied or enlarged, found an estoppel. But in our submission, AutoCleanse is authority for the proposition that there is another circumstance in which such material is admissible, and that is in circumstances where it's alleged that the written agreement does not reflect the true agreement between the parties. That, of course, was the finding of this court in the AutoCleanse case. The focus, as both Lady Justice Smith and Lord Justice Aitken said in the Court of Appeal in AutoCleanse, the focus of the inquiry must still be to discover the actual legal obligations of the parties. I may have misunderstood her, but I thought I heard Miss Rose yesterday to say that AutoCleanse was the leading case on the proper interpretation of the contract. That's plainly not right. AutoCleanse was not a case concerned with the interpretation or construction of a contract entered into by the parties. The court wasn't construing the contract. There was no doubt about what the written terms provided, and there was no doubt about the true legal meaning and effect of those words if they represented the true agreement between the parties. You can see that very clearly if we look at AutoCleanse at paragraph page 749. And at paragraph 10, in the judgment of Lord Clark, there's a reference here at the start of paragraph 10 to both documents. There was a contract that's referred to at paragraph 9, and then there was also another document that was handed to drivers that was found to be part of the contract.
Which page are you on, Mr. Gobbin?
749, my lord. 749.
Thank you very much.
And at letter J, you'll see Lord Clark has this to say: if the relevant contract was, as a matter of law, solely contained in those 2 documents, it would be impossible to bring the case within limb A of the definition, and very difficult to bring it within limb B. So Lord Clark's there recognising that if the document reflected the true agreement between the parties, this wasn't really a question of interpretation or construction at all. It was plain and obvious that the valeter, Mr. Belcher, would not have been an employee, that's the limb A definition, or a worker, the limb B definition. But that's not what this case is about. The ET made certain further findings of fact, including the following. And then he goes on to consider the operation. So the finding of fact made by the tribunal was not one of construction or interpretation, but as to the true agreement between the parties, and it disregarded the terms of the contract on which the employer AutoCleanse relied. It was, and Ms. Rose took you to this in the judgment of Lord Justice Sedley in the AutoCleanse case, but in my submission, the wording is very apt. It wasn't a question of construction or interpretation, rather it was a finding on the prior question of what the contract was. A finding on the prior question of what the contract was. Now, if we can look a little more detail at the decision of the Supreme Court of this court in AutoCleanse, the first point to note We refer, of course, to Lord Clarke's judgment. There is only Lord Clarke's judgment because this was a unanimous decision of the court, with Lords Hope, Walker, Collins and Wilson all agreeing with Lord Clarke's judgment. So it's a powerful judgment. Second, Lord Clarke expressly states, paragraph 17, that the determination of the issues in that appeal involved consideration of whether and in what circumstances the Employment Tribunal may disregard terms which were included in a written agreement between the parties and instead base its decision on a finding that the documents did not reflect what was actually agreed between them. As I say, it's not this case, but it's the important point of principle that your lordships and my lady, I think, are being asked to decide by Uber. Third, Lord Clarke expressly endorses paragraph 89 of Lord Aitken's judgment that you were taken to yesterday by Ms. Rose. I want you just to have that up very briefly to remind ourselves of what was said. In fact, if you just go to page 752, you'll see the citation of Lord Justice Aitkins in Lord Clarke's speech, so paragraph 21. In cases concerning, this is paragraph 21, in cases concerning work and services where one party alleges the written contract terms do not accurately reflect the true agreement of the parties, rectification principles are not in point, because it's not generally alleged that there was a mistake in setting out what the contract terms as they were. There may be several reasons why the written terms do not accurately reflect what the parties actually agreed, but in each case, the question the court has to answer is, what contractual terms did the parties actually agree? The Lord Justice Aitkins recognising that in the usual case where it's alleged the written terms do not reflect the actual agreement, the party so alleging can make an application for rectification. But that doesn't really work in the employment context because the putative employee is not alleging that the agreement mistakenly records their agreement, but rather because of the circumstances in which contracts for work and services are usually concluded, reflection of the inequality of bargaining power between employer and employee, employees really have very little choice and can often have terms imposed upon them that do not reflect true agreement. The rectification principle is not in point. There's a common sense point to be made here in addition to the point made by Lord Justice Aitkins, bearing in mind the purposive construction that one must give to statutes in the employment field that are designed to protect employees. It would significantly undermine that statutory regime if employees like Mr. Belcher, a valeter, were told, well, before you can enforce your employment law rights, you've got to go to the High Court on an action for rectification. The prospect of someone like Mr. Belcher being able to do that, meaningless. It would effectively deprive him of the statutory protection which the courts have held he is entitled to if he were first required to rectify the contract. And that's why Lord Justice Aitkins, with the unanimous approval of this court, invited employment tribunals to have regard to the inequality of bargaining power, be realistic and worldly wise when doing so, and when deciding whether the terms of a written agreement in truth represent what was agreed. Rather than depart from the decision of this court in auto cleanse as you're invited to do by Uber, we invite you to endorse it as being an eminently sensible approach. Ms. Rose took you yesterday to paragraph 35 of the judgment. And I just want to say a couple of words about that. Paragraph 35 is on page 756. The relative bargaining power of the parties must be taken into account, deciding whether the terms of any written agreement in truth represent what was agreed, and the true agreement will often have to be gleaned from all the circumstances of the case of which the written agreement is only a part. The second part of that sentence, of course, is not telling us anything new. It mirrors almost identically the language used by Lord Irvine in the Carmichael case. The true agreement will have to be gleaned from all the circumstances of the case of which the written agreement is only a part. It's the first phrase that Ms. Rose took issue with, the relative bargaining power of the parties must be taken into account. In the context of statutory employment protection, we say that's an entirely appropriate observation, and we invite your Lords and my Lady to endorse it. Well, as we say, that's the approach set out by the Supreme Court in the AutoCleanse case, and it is supported by EU law. It is entirely consistent with EU law. My Lords, I want to touch upon this very briefly. It still applies, of course, in the UK, and your Lordships will, of course, have regard to it. But in our submission, what might be called the Carmichael AutoCleanse approach gives effect to the jurisprudence of the Court of Justice when dealing with the status of employees or workers under European law. The first point to note is that the Court of Justice has said, and this chimes with the submissions I've made about the importance of the statutory employment protection regime. The Court of Justice has said that the right to paid annual leave under the Working Time Directive is a particularly important principle of EU social law, not least because it is expressly required by Article 31(2) of the Charter of Fundamental Rights of the EU. So a particularly important principle of EU social law expressly required by Article 31(2) of the Charter of Fundamental Rights of the EU. That was the point that was made in the Stat Wuppertal and Bauer case. I'm not going to take you to that unless you particularly want to, but if you want to look at the Charter very quickly, if you turn to page 1171, and you'll see there Article 31, fair and just working conditions. Every worker has the right to working conditions which respect his or her health, safety and dignity. Every worker has the right to limitation of maximum working hours, daily and weekly rest periods into an annual period of paid leave. And of course, your Lords and my Lady will know that the Charter has the force of an EU treaty. The criteria laid down by EU law for determining whether a person is a worker or not are best summarised in the Allenby case. And I want to take you to that very briefly at 1042. 1042. This case was concerned, as Ms. Rose mentioned to you yesterday, with whether a lecturer, college lecturer who was ostensibly self-employed would nonetheless be a worker for the purposes of an equal pay claim. But the principles set out in Allenby have been applied in a wide range of contexts, both by the CJEU, including the Working Time Directive, and also by domestic courts, including the Bates van Winkelhoff case. So Allenby is expressly referred to by Lady Hale in her judgment in that case. So although on the face of it, it's concerned only with Article 141, or what was Article 141, and the right to equal pay, the principles are more wide-ranging, giving you the references in our written case. So 1042 is the start of that case, and if I can take you to 1074, and I'll do this relatively quickly because the points are set out succinctly. Beginning at paragraph 66. Forgive me, my lords. Let me just get the page number. Yes, so it is beginning, it's paragraph 66 on 1074, forgive me. So accordingly, the term worker cannot be defined by reference to the legislation of the member states, but has a community meaning. Moreover, it cannot be interpreted restrictively. For the purposes of that provision, there must be considered as a worker a person who, for a certain period of time, performs services for and under the direction of another person, in return for which he receives remuneration. At paragraph 69, the question whether such a relationship exists must be answered in each particular case, having regard to all the factors and circumstances by which the relationship between the parties is characterised. Provided that a person is a worker within the meaning of relevant EU law, the nature of his or her legal relationship with the other party to the employment relationship is of no consequence. The formal classification of a self-employed person under national law does not exclude the possibility that a person must be classified as a worker for the purposes of EU law if his or her independence is merely notional, thereby disguising an employment relationship within the meaning of that article. And we say, albeit using slightly different language, this is on all fours with the approach adopted by this court in AutoCleanse. You look at the reality of the relationship, not the form. My lords, the latest word on this topic was given by the Court of Justice just last Thursday in the AFMB case, and it's the one that's included in the supplementary bundle beginning at page 23. And the particular relevance of that case is that it applies those principles, but in the context of a tripartite relationship. So, my lords, in the supplementary bundle at beginning at page 23, in that case, lorry drivers entered into contracts of employment with AFMB, which is a company registered in Cyprus. That company had itself entered into contracts with transport undertakings based in the Netherlands for the transport of goods both in the Netherlands and in other EU and EFTA countries. AFMB applied to the Dutch equivalent of a Social Security Appeal Tribunal, known as the SVB, for a declaration that the drivers were not subject to Dutch social security law. So employed by a Cypriot company, but working in, amongst other places, the Netherlands. So the question was whether they were covered by Dutch social security law, and that was relevant because the EU regulations in issue in that case provided, in brief, that a person employed in a member state shall be subject to the legislation of that state. So the referring court wished to know whether the lorry drivers were to be regarded as employed by AFMB in Cyprus and therefore not subject to Dutch social security law, or by the transport undertakings themselves, in which case they were subject to Dutch social security law. The important paragraphs in the CJEU judgment are at page 34. And at paragraphs 58 to 61. The reference here to the institution concerned is the domestic court or tribunal seized of the issue. So the court has stated that the institution concerned may, where appropriate, take account not only of the wording of contractual documents, but also of factors such as the way in which employment contracts between the employer and the worker concerned had previously been performed in practice, circumstances surrounding the conclusion of those contracts, and more generally, the characteristics and conditions of the work performed by the undertaking concerned, insofar as those factors may throw light on the actual nature of the work in question. And we highlight there the circumstances surrounding the conclusion of those contracts, which echoes the language of Lord Justice Aikins, you'll recall, in the Court of Appeal in AutoCleanse, the circumstances in which contracts for work or services are performed are different from the circumstances in which commercial contracts are concluded. And the CJEU goes on at paragraph 59, the court added that if it's apparent from relevant factors other than contractual documents that an employed person's situation in fact differs from that described in such documents, the obligation to apply, the regulation in that case, correctly means that it is incumbent on the institution concerned, whatever the wording of those contractual documents, to base its findings on the employed person's actual situation.
Can you remind us which of the employment rights that we're concerned with in this case are derived from EU law?
The working time regulations, my lord, are based on the working time directive. So that's the right to paid annual leave specifically. So going back then to the AFMB case at paragraph 61, whilst the conclusion of an employment contract, reference here to an employment contract, please don't be confused by it. Of course, the employment contract was concluded with the Cypriot company. The issue was whether that was the genuine employment relationship. So here, the conclusion of an employment contract between the employed person and an undertaking may be an indication of a hierarchical relationship between the former and the latter. But that circumstance alone cannot permit a definitive conclusion that there exists such a relationship. It remains necessary in order to arrive at such a conclusion to have regard not only to the information formally contained in the employment contract, but also how the obligations under the contract incumbent on both the worker and the undertaking in question are performed in practice. Accordingly, whatever the wording of the contractual documents, it is necessary to identify the entity which actually exercises authority over the worker, which bears in reality the relevant wage costs, and which has the actual power to dismiss that worker. So whatever the wording of the contractual documents, have regard to the reality. And the ruling, paragraph 80, page 2334, the employer of an international long-distance lorry driver for the purposes of the relevant provisions is the undertaking which has actual authority over that long-distance lorry driver, which bears in reality the costs of paying his or her wages, and which has the actual power to dismiss him or her, not the undertaking which that long-distance lorry driver has concluded an employment contract with and which is formally named in the contract as being the employer of that driver. So Uber may say, well, this case, of course, helps us. We're the intermediary. We're the Cypriot company. Uber drivers provide their services to passengers, just as in this case, the lorry drivers provided their services to the Dutch undertakings rather than to the Cypriot company. But we say that's to miss the point of this judgment. In our submission, the AFMB case is clear authority for the proposition that for the purposes of EU rights in the field of social law, which includes the Working Time Directive, a worker is employed by the undertaking which has actual authority over him or her, including the power to dismiss, and which is responsible for paying the wages. And that the court can and must disregard any third-party contract which purports to create instead a relationship with that third party. And in our submission, that is entirely consistent with what my Lady Arden noted when in the Court of Appeal in the Halawi case. It's not one in the authorities bundle, but it's referred to in our written case. Namely, that the existence of a relationship of employment in EU law does not turn on whether the parties entered into a formal contract, which would be recognised in domestic law as constituting employment, but on whether it meets the criteria laid down by EU law. My Lord, my Lady, we say that is the correct approach to be adopted in this case. Finally, just on this topic, please note in our written case, we do rely on two further decisions on the topic of EU law. One, of course, not binding on this court, the decision of the highest court in France, the Court of Cassation, which arrived at the same conclusion as the EAT in the Court of Appeal in our case, that Uber drivers are employed by Uber. My Lord, I've dealt with this at some length in my written case, sorry, I should say our written case, but you will note if you look at that judgment that all of the points that are raised before your Lordships, and my Lady in this case, were raised before the Court of Appeal and then the Court of Cassation in France, and were rejected by the court there. So the highest court in France has rejected these arguments. It might just be worth noting that that was so notwithstanding the fact that under French law, there was a presumption against employment status for those in the position of Uber drivers. If you want to see that very quickly, at 1128 in the electronic bundle, please. At paragraph 7, in accordance with the French Labour Code, natural persons, when conducting operations necessitating a filing in the registers or repertoires listed in this article, and that included people such as Uber drivers, are presumed not to be bound by the principle to an employment contract. Nevertheless, the existence of an employment contract may be established in cases where said persons provide services under terms and conditions placing them in a relationship of permanent legal subordination. And the relationship at paragraph 8 of legal subordination is characterised by the performance of a job under the authority of an employer who has the power to give orders and instructions, to oversee performance thereof, and to sanction the subordinate for any breaches. In accordance with the aforementioned case law, working within an organised service may constitute an indication of subordination in cases where the employer unilaterally determines the terms and conditions of performing the job. And we'll say the French Court of Cassation there was correctly applying the approach mandated by the Court of Justice, notwithstanding the presumption against the drivers in France. There is, of course, reference to legal subordination there. Ms. Rose took you to the judgment of Lady Hale yesterday, in which she said, in fact, subordination is not. I'm sorry, my Lord, Lord Sales.
Sorry, do finish your point on this case, but when you do, I'd just like to ask you something about statutory interpretation in light of these EU authorities.
Yes, of course, my Lord. So just a short point to make here is that Ms. Rose took you yesterday to Lady Hale's judgment in the case of Bates, in which she said subordination is not a requirement, in fact, of employment status under domestic law. If that's right, if anything, UK law goes further than the position in France. It's certainly not any narrower than the position in France, where a relationship of legal subordination is apparently required, albeit in the terms set out by the Court of Cassation there. I'm sorry, yes, my Lord.
Thank you. Yes, I wanted to ask about the significance of the EU authorities. I mean, clearly they're authoritative in relation to the Working Time Directive, as my Lord Reid pointed out. But I wondered whether they have wider significance as well. I mean, my broad understanding is that the concept of worker in UK statutory law, although the formula may go back to the 19th century, has regularly been essentially relied upon by Parliament as the relevant EU concept whenever implementing EU law. And so my question really is whether you say that we gain interpretive assistance from the EU authorities, not just in relation to the Working Time Directive, but in relation to the other statutory provisions which use the same formula domestically.
My Lord, yes. Of course, the rule that the UK court is bound to apply EU law or UK law that implements EU law consistently with Court of Justice jurisprudence won't apply directly in that context. My Lord's asking whether it has, if you like, a broader significance, and that you can take note of the fact that the interpretation or the definition of the term worker under EU law must apply more broadly because that concept is used across the board. My Lord, we'd certainly endorse that. What we'll say is you see that in the domestic authorities, both the ones I've already taken you to, the approach set out by the court, House of Lords in Carmichael, by this court in Autocleanse, and we'll come and touch upon briefly in my submissions, then developed by Mr. Siegel in his submissions. The approach taken in the tax cases, in fact, is entirely consistent, albeit concerned with a very different concept, but entirely consistent with that, to the facts answer to the statutory language. And we say that that approach actually does have broader application, absolutely.
Yes, I think my point was really that before you get into the Marleasing
yes,
synthetic interpretation obligation, you first ask, what did Parliament mean? You only have to resort to that special obligation if there's a gap between what Parliament meant and what EU law provides. But if Parliament actually intended the relevant concept to be the EU law concept, you don't need Marleasing, and then it's possible to say that Parliament intended generally the concept of worker to correspond with the concept of worker in EU law.
Well, my Lord, that's absolutely right, of course, when implementing EU law. So any UK rights that are based on EU law, that's absolutely right. Whether it goes further than that, I'm not aware of any authority to that effect, but certainly we'll try and find something over the short adjournment.
All right, thank you.
This is what I was. This was actually the point of a question I put to you earlier. There's the concept of a Lim B worker has a very wide application, and we may. It's inherently unlikely that Parliament intended the concept to be given one meaning, or indeed it's very unsatisfactory if it's given one meaning in the context of implementing EU rights, and a different meaning if the context is domestic.
My lord, I agree, and of course it is right that Uber are not suggesting in this case that you ought to give a different interpretation to the term worker as used in the working time regulations, as opposed to the term worker as used, for example, in the minimum wage legislation, which is not underpinned by EU law. So there's no suggestion in this course that there ought to be a different interpretation. So to that extent, it must follow as a matter of practicality that whatever definition you give as a result of the impact of EU law in relation to the term worker under the Working Time Directive will follow into your Lordship's ruling on National Minimum Wage Act.
The function of Section 54 was to catch the people whom you need to catch for minimum wage purposes, who are not who are among the pool of self-employed people.
Indeed.
So you're peeling off part of the group. Now, is it really going to be helpful? How far do you take European law? Because we still have to go into the further questions, whether they're in that middle ground within the self-employed class.
Yes, Milady's referred to the National Minimum Wage Act. It's worth then actually looking at the National Minimum Wage Act, because that arguably goes even further, because there's a statutory reversal of the burden of proof in the National Minimum Wage Act, which of course the claimants are entitled to rely on. So if you have that, it's worth looking at Section 1 of the National Minimum Wage Act. That's at 699. We were taken to this yesterday by Ms. Rose. 699, Section 1, subsection 2, a person qualifies for the national minimum wage if he is an individual who is a worker. And then if you go to 701, Section 28, where in any civil proceedings any question arises as to whether an individual qualifies or qualified at any time for the national minimum wage, it shall be presumed that the individual qualifies. Now, having looked at Section 1, that can only mean whether the individual is a worker. For present purposes, I only took you to the first part of subsection 1.2, but for present purposes, any question arises as to whether an individual is a worker, it shall be presumed that they are. And that's how Lord Justice Elias interpreted that section in the James and Redcats case. I'll take you briefly to that at 838. This is within James and Redcats. Forgive me for, in the interest of time, I'm taking you to the relevant passages, but at paragraph 5, section 28.1 establishes a presumption that an individual who claims to be covered by the Act does fall within its terms. It thereby places the burden of proof on the putative employer to rebut that presumption by showing that the individual is not a worker within the meaning of the Act. And then to 849, Lord Justice Elias considered how that impacted on the issues that he was then deciding. Paragraph 69, so page 849, paragraph 69.
In paragraph 6, Robert makes the point that the definition of a worker is identical in relation to national minimum wage,
indeed,
working time regulations, and the Employment Rights Act. And plainly, in the context of working time regulations, it must be intended to fulfill our obligations under EU law.
Indeed.
And so unless Parliament intended it to have a different meaning in the other two contexts, you would infer that it has the EU meaning?
Indeed, and there's no suggestion in any of the authorities that Parliament did so intend, and it's no part of Uber's case that Parliament did so intend. And then paragraph 69, Lord Justice Underhill arguably doesn't even give full effect to the reversal of the statutory burden of proof. He says that paragraph 69, the statutory provisions relating to the burden of proof must have some significance in the judicial balancing exercise, and the definition in that act is under consideration. Seems to me the effect of the presumption is that when balancing the various features of the relationship, necessary to ask not whether the features of the contract are consistent with somebody working on business on his own account, but rather whether they are consistent with, or at least not inconsistent with, performance of services by someone who is self-employed but who does not conduct his or her own business, i.e. that middle category identified by Lady Hale. And we would paraphrase that to say it's really an answer to Ms. Rose's case here, that the effect of that reversal of the burden of proof is to ask not whether the features of the contract are consistent with an agency relationship, that's the wrong approach, but rather to ask whether they are consistent with, or at least not inconsistent with, a worker relationship. And we invite you to so rule. My Lords, it's right that the Employment Tribunal doesn't expressly refer to Section 28, but it's right that your Lordships and my Lady are aware of it, and it forms part of my argument, but we invite you to adopt that approach. My Lords, my Lady, that's what we say is the correct approach to be adopted in this case. Can I very quickly then just look at the Secret Hotels case and really to say, so what of it? How does it help, really? The short submission is that the Secret Hotels case was concerned with a very, very different legal and factual scenario. You only need to look at paragraph 31 in the judgment to see that, page 981. So the correct approach at paragraph 31 identified by Lord Neuberger, relevant to the facts of that case, where parties have entered into a written agreement which appears on its face to be intended to govern the relationship between them, then in order to determine the legal and commercial nature of that relationship, it's necessary to interpret the agreement in order to identify the parties' respective rights and obligations, unless it's alleged that it constitutes a sham. Well, we don't take issue with any of that. That was the task facing the court in that case, because it was not suggested by either party that any of the documents relied on were a sham, and it was purely a question of construction. Lord Neuberger does, of course, record at paragraph 32, when deciding on the categorization of a relationship governed by a written agreement, the label or labels which the parties have used to describe their relationship cannot be conclusive, may often be of little weight. Again, we agree. Paragraph 33 at the bottom, in English law, it's not permissible to take into account the subsequent behaviour or statements of the parties as an aid to interpreting their written agreement. Of course, we agree. But the subsequent over the page, the subsequent behaviour or statements of the parties can, however, be relevant for a number of other reasons. First, they may be invoked to support the contention that the written agreement was a sham, i.e. not in fact intended to govern the parties' relationship at all. That's also cleansed. We agree. And then at 34, in the present proceedings, it's never been suggested the written agreements were a sham or liable to rectification, nor has it been suggested terms contained on the website were a sham or liable to rectification. In these circumstances, the right starting point is to characterise the nature of the relationship between Med, the customer, and the hotel in the light of the relevant documents. One must next consider whether the characterisation can be said to represent the economic reality of the relationship. We don't take issue with any of that. It's got nothing to do with our case. But even if we have to go further in supporting the auto-cleanse approach in cases where there is a written agreement between the parties, Secret Hotel says no more than you start by identifying the legal rights and obligations of the parties, and the written agreement might be a convenient starting point. Well, I don't think anyone can take issue with that. The effect of the agreement can be displaced if it does not reflect the economic reality of the relationship in the light of any relevant facts. Well, we don't take issue with that. Lord Neuberger uses the language of economic and commercial reality because, of course, he's dealing with a commercial case. It reflects the language used by the Court of Justice in the Newey case In paragraph 29 of that judgment, look very briefly at 980. I think Mr. Siegel's going to come back to talk about this, so I'll just touch upon it very briefly. You can see there's reference at the foot of the page to Revenue and Customs Commissioners against NUI. As regards paragraph 42, the importance of contractual terms necessary to bear in mind, case law of the court, consideration of economic and commercial realities is a fundamental criterion. Given the contractual position normally reflects the economic and commercial reality of the transactions, in order to satisfy the requirements of legal certainty, the relevant contractual terms constitute a factor to be taken into consideration. 44, it may, however, become apparent sometimes certain contractual terms do not wholly reflect the economic and commercial reality. That is the case in particular if it becomes apparent those contractual terms constitute a purely artificial arrangement which does not correspond with the economic and commercial reality of the transactions. So we see there why Lord Neuberger used that language in the context of a commercial case. But plainly, the language used by this court in AutoCleanse is more apt to describe the same task within the context of a relationship concerned with work or services.
When you ask what the economic reality is, you're starting down the path of recharacterizing, recasting, and rewriting the transaction to look at it functionally. And that's not what AutoCleanse requires, is it?
No, absolutely.
Like the true agreed. So it wouldn't be right, would it, to adopt the concept of economic reality in this?
Well, Milady, I was going to say actually that one could dispense with the words economic and commercial completely and say the principle is that a written agreement can be displaced if it does not reflect the reality of the relationship. That's the point.
Yes.
And economics snuck in here simply by reference to NUI, but the principle is you displace the written agreement if on the findings made by the court tribunal it doesn't reflect the reality.
That you get for AutoCleanse itself.
Yes, indeed. And all we say is that Secret Hotels doesn't take it any further. It's simply an application of the same principle in a commercial context, albeit in a case where there was no allegation of sham. As regards the broader point made by Ms. Rose, and I'll just make this short point and then perhaps, my Lord, we might have our morning break, but as regards the broader point, this was the one accepted by Lord Justice Underhill, paragraph 153 in his judgment. I don't need you to take you to it, but that an agent can sometimes exercise significant control over its principal, and that Secret Hotels is authority for that proposition. Well, that's not really a proposition of law. As a matter of fact, significant control by a putative agent over the putative principal might, in an appropriate case, indicate that the relationship is not that of principal and agent. In another case, it might not. Each case will depend on its own circumstances, as Lord Justice rightly acknowledges. Ms. Rose yesterday said, well, we're in a very similar situation to the travel agent in the Secret Hotels case. We say that's absolutely not right. And I don't think I can put it any better than Advocate General Spunar did, actually, in the Spanish CJEU case, the case that's referred to in our written case about whether Uber had to have a license to operate in Barcelona. My lords, my lady, we rely on that in our written case, but just to rebut this point about the factual circumstances and the the factual differences between our sort of case and that sort of case, can I ask you just to look up page 1935? This is not binding on this court, of course, but it encapsulates what I would have said about it. Paragraph 57 at the foot of 1935. I think it's wrong to compare Uber to intermediation platforms such as those used to make hotel bookings or purchase flights. Yes, there are some similarities at paragraph 58, but over the page at 59. In contrast to the situation of Uber's drivers, both hotels and airlines are undertakings which function completely independently of any intermediary platform, and for which such platforms are simply one of a number of ways of marketing their services. Furthermore, it's the hotels and airlines, not the booking platforms, that determine the conditions under which their services are provided, starting with prices. The undertakings also operate in accordance with rules specific to their sector of activity, so that booking platforms do not exert any prior control over access to the activity, as Uber does with drivers. Lastly, such booking platforms give users a real choice between several providers whose offers differ on a number of important points from the user's perspective, such as flight and accommodation standards, flight times, hotel location. By contrast with Uber, these aspects are standardized and determined by the platform, so that as a general rule, the passenger will accept the service as the most quickly available driver, those little cars on the app that Ms. Rose referred to yesterday. Uber is therefore not a mere intermediary between drivers willing to offer transport services occasionally and passengers in search of such services. On the contrary, Uber is a genuine organizer and operator of urban transport in the cities where it has a presence. We agree. Lord, if that's a convenient moment.
Yes, thank you very much, Mr. Galbraith-Martin. We'll sit again in about 5 minutes' time.
Thank you.
I think we're now ready to continue, Mr. Galbraith-Martin.
The claimants, I've just come on. I'd like to turn to the question of whether the Employment Tribunal is entitled to conclude that the claimants are workers for the purposes of the relevant statutory provisions. The real issue in this case has always been in our submission, who do Uber drivers perform their work for? The Employment Tribunal found that they work for Uber. And in our submission, that was a finding that it was open to it to make on the evidence before it. The critical findings of fact are set out in paragraph 77 of our written case, page 159 if you want to look at it. But it's important to bear in mind that in making those findings, the Employment Tribunal necessarily also found that the terms on which Uber rely do not reflect the reality of the relationship. This is something that Lord Justice Underhill in his dissenting judgment really doesn't engage with at all. I want to focus on two matters in particular, which we say are critical, actually, to the relation to an employment relationship. That is the question of control and the alleged freedom to decline or cancel trips. So looking first at the question of control, it's been identified as one of the defining features of an employment relationship since the seminal judgment of Mr. Justice McKenna in the ready mixed concrete case some 50, 60 years ago. It's a case that's cited in nearly every employment status case, and unsurprisingly, it's cited by Lord Clark in AutoCleanse. If I can ask you to look at the citation of it in AutoCleanse, please, at 751. Paragraph 18 from the judgment of Lord Clark. A contract of service exists if the following three conditions are fulfilled. The servant agrees that in consideration of a wage or other remuneration, he will provide his own work and skill in the performance of some service for his master. He agrees expressly or impliedly that in the performance of that service, he will be subject to the other's control in a sufficient degree to make that other master, and the other provisions of the contract are consistent with its being a contract of service. Freedom to do a job by one's own hands or by another's is inconsistent with a contract of service. A limited or occasional power of delegation may not be. So he there focuses as a second criterion on the issue of control. Now, yesterday, Ms. Rose said, well, control is only really relevant to the third criterion of the worker relationship, the question of whether the putative employee deals with the putative employer in a relationship of client and or customer. But we can see here that that must be wrong, because Mr. Justice McKenna is considering the concept of control when asking whether a contract of service exists. That's a Lim A contract of service. He wasn't concerned at all with the Lim B worker definition, and therefore wasn't concerned at all with the client-customer exemption. He's rightly pointing out that control is a feature of a contract of service. It is equally, therefore, a feature of a worker contract, but not specifically or only in relation to the client or customer exemption. It's identified, I accept, by Mr. Justice McKenna here as a second criterion, after that the servant agrees in consideration of a wage or other remuneration to provide his own work. But of course, it logically follows one can only exercise control over someone that is in a relationship with. So it naturally presupposes that the servant is providing his own work or skill in the performance or service of some service for his master. It's in those circumstances that you then go on to ask whether he does so expressly or impliedly, subject to the other's control. So by default, it's a useful indicator of whether the individual is working for the other party to the contract, or, for our purposes, who's working for whom. Contrary to the express terms on which Uber relies, finding of fact made by the tribunal was that it does exercise a significant degree of control over its drivers. And note, Ms. Rose several times yesterday referred to the non-exercise of a contractual power. The non-exercise of a contractual power doesn't mean you don't have that power. Well, except that's right. But this is a rather different situation. We're not here talking about the non-exercise of a contractual power. We're talking about exercising a power over drivers that the written terms expressly state Uber does not have. So if we look first at the terms, page 545. And at paragraph 2.2 in the new terms, reading about 5 lines up from the bottom, as between Uber and customer, customer acknowledges and agrees that customer and its drivers are solely responsible for determining the most effective, efficient, and safe manner to perform each instance of transportation services. Over the page, clause 2.4. 3 lines down, Uber and its affiliates in the territory do not and shall not be deemed to direct or control customer or its drivers generally or in their performance under this agreement specifically, including in connection with the operation of customers' business, the provision of transportation services, the acts or omissions of drivers, or the operation and maintenance of vehicles. And at 2.5, 3 lines down, customer acknowledges and agrees that it exercises sole control over the drivers. But contrary to those express written terms, the finding made by the tribunal is that Uber does instruct drivers how to do their work and in numerous ways controls them in the performance of their duties. That's the finding made at paragraph 92.7, page 393. In our submission, the evidence in support of that was overwhelming. It includes the following. At the point of recruitment, drivers are given a welcome packet, which incorporates instructions about how the services are to be provided. The tribunal refer to this in paragraph 48 of their reasons, but they do it by reference to a document, and we've got the document in the bundle at page 600. If you're looking at it electronically, it's quite easy to rotate the view. It might appear on its side. So what you have there is a page from the welcome packet headed Safety and Quality. So this forms part of the onboarding process, what happens when drivers attend at Uber London. And they're told that they must be polite and professional at all times. They're told that they must avoid inappropriate topics of conversation. They're told not to contact the driver after the trip has ended. They're required to complete what's called a partner driver information test, or a PIP test, that has a pass mark. You'll see that if you just go on another couple of pages at 603. So hopefully at 603 you have the Uber partner driver in-person test, and you'll see that the pass mark is 70%. Third line up in the text next to the picture. To give you an idea of the sort of things this covers, on page 605, what would you do at the start of every trip? Introduce yourself to the rider and help with any luggage. Page 607, what could you try to do if your rider doesn't know his exact address? Ask the rider if they know what area it's in. What would you do if you took a wrong turn? Be honest with the rider. And so it goes on. It's not just control, it's micromanagement. Now, Uber might say this is all just a matter of common sense. Although some of us, I'm sure, have had some experiences of some of the negative things that are being referred to in that documentation, but it's not the point. These are instructions that are given by Uber London to its drivers. And once drivers have passed the recruitment stage, Uber continues to exercise day-to-day control over them. They're issued with standards advice, the document at 673. These are said to be recommendations, but the tribunal pick up what's said at the third paragraph here. There are some recommendations that if followed, if not followed, not's missing at the end of the page perhaps, may constitute a breach of your partner terms or license conditions. And then if you go to page 675, recommendations for safe driving. You should always be considerate of other road users and aware of cyclists. It's advisable to drive in a manner that's comfortable for passengers. Drive responsibly, take breaks. Under 3, do not discuss sensitive or personal topics. Again, examples of micromanagement, not just at the point of recruitment, but throughout the relationship. Your Lordships, my lady will be aware, the tribunal has also found that Uber effectively determines the route taken by drivers because it sends them the route on the app and they depart from it at their peril. This finding was also supported by the evidence. If you look at 513, my client, Mr. Farrer, asking at the very top of that page, hopefully you can make it out, to Uber, please explain this adjustment at the top of the page. And then towards the bottom, hi James, thanks for letting us know. I'm sorry to hear your pay was reduced. Hope you're doing okay. I've reviewed the trip and can confirm the fare was adjusted due to the rider's feedback about the inefficient route that resulted into a higher than usual level of pay. We recommend using the in-app navigation. Well, it's a recommendation, but if you don't follow it, we'll reduce your pay. That's without even reference to my client. Whereas you'll recall the express terms say, in theory, drivers have absolute control over determining the most efficient route to be taken. We know that Uber deliberately does not tell drivers, or certainly did not at the material time, the passenger's destination until the passenger has been picked up. And that's to ensure that drivers do not screen trip requests, i.e. they don't say, I don't feel like going to that particular location. And the rationale for this was explained in Uber's response to TfL's consultation, that document we looked at the start of my submissions this morning. But if you go back to it, please, at 521. And it's on the second page. 522, penultimate paragraph beginning there, has long been strong anecdotal evidence of private hire operators and taxi drivers effectively screening booking requests to adhere to their own criteria, distance, area, etc. The fact, this is 3 lines from the bottom, the fact that an Uber driver only receives the destination for a trip fare when the passenger is in the car is a safeguard that ensures that we can provide a reliable service to everyone at all times, whatever their planned journey. Now, yesterday, Ms. Rose said, well, this is covered by clause 2.2. In fact, clause 2.2 says the exact opposite of that. Clause 2.2 on 545. So clause 2.2, page 545, 5 or 6 lines from the top, beginning halfway along, you'll see where it says driver will obtain the destination from the user, either in person upon pickup or from the driver app if the user elects to enter such destination via Uber's mobile application, if the user elects to enter such information via the mobile application. Now, Ms. Rose also helpfully reminded you yesterday of the finding of fact made by the tribunal at paragraph 15, that passengers usually do notify their destination at the time of booking. That's page 367. So Uber is aware of that information at the time of booking, but it deliberately does not provide that information to the drivers to prevent them screening trips. My own client, Mr. Farrar, gave evidence about this, page 623. Here's an extract from his witness statement. So the only information I receive about the customer's request for a journey is the customer's current location and the customer's average rating. Paragraph 60 of his witness statement, I'm not told anything else about the trip request. In particular, I am not told the customer's requested destination. So we know for its own commercial reasons, Uber does not provide that information to the drivers, but that, we say, is wholly inconsistent with an agency relationship in which drivers allegedly have complete control over their own businesses. It's actually a freestanding inconsistency, although I've dealt with it under the heading of control. We know that Uber monitors its drivers' performance. It can require them to undertake additional quality training. That's the rating-based quality process that begins at 652. Ms. Rose said yesterday, the ratings, that's all just about access to the app. That's not true either. It's part and parcel of a performance management process operated by Uber London. Drivers can be required to come back in to Uber London and to retake the PIP test. Get some hint of that at page 660. Ask partner drivers right in the middle of that page to complete the short repeat PIP test. Over the next page, on 661, drivers can be asked to repeat the onboarding test. And at the very foot of 662, checking the partner driver's test scores, a default setting has been enabled requiring partners to watch 100% of the videos and score 100% in all quizzes in order to reach completion. This is not just about access to an app. It's a performance management process. Uber also exercises disciplinary control over its drivers. Uber London, the driver offence process. Page 644. And I just want to give you an example of the sort of things that would merit action under this process. It's page 650, my lords. I hope you can read it, or you might need to zoom in. So these are the sort of examples of the conduct of drivers that have resulted in Uber taking action under this process. If you can just about make them out, on the far right-hand side, the second one down is poor English. About 8 further down from there, you'll see very high supply hours. Driver looked tired. Uncomfortable driving. Towards the bottom, refused multi-stop. Refused destination. Inappropriate discussion. Argument with rider. Stopped for petrol. These are the sort of things that Uber takes action against its drivers for. Wholly inconsistent with the written terms that say how you run your business is your concern. In our submission, the tribunal's finding that Uber instructs drivers how to do their work and in numerous ways controls them in the performance of their duties was plainly one it's entitled to make, and we say it certainly cannot be characterised as perverse. Next, the obligation to accept work. We start from the proposition that what matters is the contractual position when drivers are actually working rather than when they are not working. My Lords, I set out our reasons for saying that by reference to authority, and in particular the judgment of Lord Justice Elias in the Red Cats case, paragraphs 65 to 70 of my written case, but I don't understand any of those matters to be controversial. So let's go again to the contractual term at 546. Paragraph, clause 2.4, 10 lines down towards the end of the line, customer and its drivers retain the option via the driver app to decline or ignore a user's request for transportation services via the Uber services or to cancel an accepted request. So they retain the option to decline or ignore a request for services. But the finding the tribunal make is that drivers are not free to decline trip requests as they see fit, but are in fact required to accept at the very least some trip requests, finding at paragraph 92.4, page 393. That again was based on the evidence. In fact, it was largely based on Uber's own evidence. If you go, please, to the evidence of Joanne Bertram, an extract from her witness statement, page 179. But it so it's page 152, forgive me, page 152, paragraph 179.
I don't think so.
I will get my junior will find me the correct page reference. You're quite right, my lord. I've got the wrong page reference down. She'll find it for me and I'll take you back to it. But can we look briefly at the notes of her cross-examination? We'll come back to Chief in a moment. But the notes of her cross-examination, you'll recall, and Miss Rose told me there was some dispute about what Miss Bertram said in cross-examination. So we applied for and obtained the employment judge's notes of evidence, and those begin at page 682. And you'll see the question that was put towards the top. Drivers are told 80% acceptance required. Don't think it's that now. People are asked to log off if not available. And she was asked, do you challenge the 80%? It may have been said in the past. It's typical. She says not used now. Again asked about the 80%. She says it's a global web page. But then the judge asks the EJ, why tolerate less than 80% in London? Is a lower standard acceptable? And she answered, I do not say London accepts a lower standard. Enforcement kicks in at a lower level, but they do not accept a lower standard in London. Let me just get the reference for Miss Bertram's statement begins at page 633. Apologies. So paragraph 179 of Miss Bertram's statement, page 635. I've seen the claim form and am aware of the paragraph in which the claimants understand that drivers are required to confirm at least 80% of the booking requests sent to them. This is not correct, although drivers are expected to confirm availability to carry out most of the booking requests sent to them. Even Uber's own documents record an obligation to accept a reasonable number of trip requests. you'll recall that in addition to the new terms, drivers are required to sign up to a driver addendum. That's the document that begins at 542. I'm sorry, 562. And again, it largely replicates the provisions that are contained in the main agreement. Although I've lost the precise point. I'll come back to that, but it's in that document. I'll come back to that page number. We also have the evidence from the lead claimants. So my client, Mr. Farrer, page 624. So paragraph 62 here refers to the 80%. Drivers are required to accept at least 80% of all trip requests. But he then goes on to say that that was applied in practice. Paragraph 63, in an email to one of the other claimants in this claim, Uber advised him, we recommend partners to receive at least 85 to 100% of the trip requests as to not get your acceptance rate affected. We don't have this particular email in the bundle, the one that's being referred to, but we do have another at 571. This is a Twitter feed in which Uber support responds to comments made by its passengers on Twitter. And you'll see two passengers are complaining about the fact that drivers are screening fares. At the top, hey Uber, your drivers at London Heathrow, London are screening fares, asking where I'm going and then cancelling trips. I have this too, and I want to go for E1 to E3. They don't want a short trip. Now, in theory, under the express written terms, drivers should be free to make those sort of decisions. But the response from Uber support was definitely not okay. Drivers are not free to refuse trips that they don't want to take, for example, because they're only short. Well, Lord, we therefore invite you to find that contrary to the express written terms in clause 2.4 of the new terms, drivers do not have an absolute or unfettered right to decline trip requests, and the Employment Tribunal was entitled to and correct to find that drivers are contractually required to accept, at the very least, a reasonable number of trip requests whilst logged on to the Uber app. My Lord, as I mentioned in opening, we say there are other features of the relationship that are inconsistent with agency, and other features of the relationship which are inconsistent with the express terms. We deal with that in our written case, paragraphs 114 to 117. I'm not going to take you to them, but Mr. Siegel is going to develop the point about other features that are inconsistent with agency. So in our submission, therefore, there are two findings made by the tribunal about control, about the obligation to work, which, taken together with the uncontested facts, drivers are required to perform their work personally. Uber is not a client or customer of any business carried on by its drivers. Those facts together satisfy the statutory criteria. And the claimants are therefore workers, and the tribunal was right to reach that conclusion. As I noted in opening, there can be no substitute for applying the words of the statute to the facts of the individual case, as Lady Hale said in the Bates van Winklehoff case. But that's not an approach, as my lords already indicated in discussions we've had about the tax cases, that's not an approach that's peculiar to the field of employment. And as Lord Clark noted in AutoCleanse, citing a number of landlord and tenant cases, it is of general application. I want to take you to just two because I think they make the point really rather nicely. So Street and Mountford, first of all, and this judgment of Lord Templeman in that case, 1887. These were landlord and tenant cases. The facts don't particularly matter, but at letter F on 1887, Lord Templeman has this to say: if the agreement satisfied all the requirements of a tenancy, then the agreement produced a tenancy, and the parties cannot alter the effect of the agreement by insisting that they only created a license, a manufacture of a 5-pronged implement for manual digging, results in a fork, even if the manufacturer, unfamiliar with the English language, insists that he intended to make and has made a spade. And then the AG Securities and Vaughan case, 1253, please. This is Lord Oliver. Since lettings of residential property of an appropriate rateable value attract the consequences of controlled rent and security of tenure provided by the Rent Acts, it's perhaps not altogether surprising that those who derive their income from residential property are constantly seeking to attain the not always reconcilable objectives on the one hand of keeping their property gainfully occupied, and on the other of framing their contractual arrangements with the occupants in such a way so as to avoid, if they can, the application of the Acts. And you can substitute in there running a transportation business as Uber does, and control over its drivers. Since it's only a letting which attracts the operation of the Acts, such endeavours normally take the form of entering into contractual arrangements designed on their face to ensure that no estate is created in the occupant for the time being, and that his occupation of the land derives merely from a personal and revocable permission granted by way of licence. The critical question, however, in every case is not simply how the arrangement is presented to the outside world in the relevant documentation, but what is the true nature of the arrangement. The decision of this House in Street and Mountford established quite clearly that if the true legal effect of the arrangement entered into is that the occupier of residential property has exclusive possession, an ascertainable period, a tenancy is created, whatever label the parties may have chosen to attach to it. And finally, at 1245, just picking up on a point my Lord Legate made yesterday about contracting out. Lord Templeman relied on that in the context of landlord and tenant cases. You'll see at 1245, beginning at letter E, since parties to an agreement cannot contract out of the Rent Acts, a document which expresses the intention, genuine or bogus, of both parties or one party to create a licence will nevertheless create a tenancy if the rights and obligations enjoyed and imposed satisfy the legal requirements of a tenancy. And we say the same applies here. If the rights and obligations enjoyed, as found by the tribunal, satisfy the legal requirements of worker status, they are workers. My lords, my lady, we say something very similar emerges from the tax cases that my Lord Reid referred to yesterday. Mr. Siegel is going to say a little bit more about them, but for my purposes, I rely on what Lord Nichols had to say in the Barclays Mercantile case. And you have that at 789. Beginning at paragraph 28, so 789 at the foot of that page. As Lord Steyn explained in the McGuickian case, the modern approach to statutory construction is to have regard to the purpose of a particular provision and interpret its language so far as possible in a way which best gives effect to that purpose. And then reading on at paragraph 32, 790, the essence of the new approach was to give the statutory provision a purposive construction in order to determine the nature of the transaction to which it was intended to apply, and then to decide whether the actual transaction answered to the statutory description. It might be more convenient to analyse the facts and then ask whether they satisfy the requirements of the statute. However one approaches the matter, the question is always whether the relevant provision of the statute on its true construction applies to the facts as found. Lords, my lady, we endorse that. And summarised by my Lord Reid in the UBS case that you drew my attention to yesterday, and I'll gratefully rely on what my Lord had to say there. The facts must be analysed in the light of the statutory provision being applied. That was at paragraph 68. It's page 77 in that additional bundle of documents that was sent to you. My Lord, we therefore invite you to find that the Employment Tribunal was right to conclude that the claims meet the statutory definition of a worker and to dismiss the appeal in relation to finding 1. I just want to say a little, as I've got a couple of minutes left before I hand over to Mr. Siegel, a little about the regulatory regimes. I think it's important to note that the tribunal didn't place any great reliance on the regulatory regime. It's referred to only very briefly in the tribunal's reasons at paragraphs 58 to 60. It's no part of the tribunal's reasoning that the relationship existed because of the regulatory regime. In our submission, requirements imposed or arising from the regulatory regime plainly can also exist as contractual obligations as between Uber and its drivers. And we say that much is clear from the fact that access to the app is personal to a particular driver and is non-transferable. Drivers are not allowed to share their driver IDs. And this was correctly identified by the tribunal, paragraph 39 of its reasons, as imposing an obligation of personal performance. So there's a contractual obligation of personal performance, even in the documents relied upon by Uber. And of course, the regulatory regime provides a like effect that a trip request accepted by an operator has to be carried out by a particular named driver, i.e., you can't substitute under the regulatory regime. It's common ground that the practical effect of Regulation 11F is to much the same effect as the contractual provision contained in the terms. So we say that's an example of a matter arising by virtue of the regulatory regime that's found its way into a contractual obligation as between Uber London or as between Uber and drivers. And if it's right, one can have a contractual obligation of personal service, notwithstanding the fact that it's also something required of the regulatory regime, well, then one can have other provisions that are incorporated into a contract between Uber drivers and Uber London, notwithstanding the fact that they're also required by way of the regulatory regime. And my lords, I won't repeat the points I made earlier in my submissions about the fact that there must be some sort of relationship between Uber London and its drivers. Otherwise, how does Uber London fulfill its statutory obligations under the regulatory regime? My lords, those are the submissions that I wanted to make in relation to the first ground of appeal. As I mentioned yesterday, Mr. Siegel is going to cover, if he feels there's time, what counts as working time. Unless you have any other questions, I'll hand over to him.
I think not. So thank you very much, Mr. Galbraith-Martin. Yes, Mr. Siegel.
Good afternoon, everyone. I invite the court to begin by imagining the following scenario. Uber London has just won its Transport for London license. The document is at 485. Uber London, not Uber BV, is now entitled, at the top of the page, to operate private hire vehicles in London and to, a little further down, accept bookings for those private hire vehicles. It needs a workforce of drivers to enable it to do so, which it recruits following interview. Successful applicants are asked to enter into standard form contracts with Uber London, which include the following dozen or so terms. Drivers must provide vehicles of a particular sort. When logged on, they should take on driving jobs which Uber London has accepted from its customers, whatever the destination, which they will only be informed of once they pick the customer up. Once a job is accepted, the driver should not cancel. If the driver does not accept trips when logged on, or if he cancels once he has accepted, then Uber London may penalise him by logging him off for a period, in effect reducing the wages he can earn. And ultimately, Uber London can terminate the contract. The driver does not provide, must not provide, his full name or contact details to the passenger, nor ask for the passenger's full name or contact details. Nor will Uber London provide the passenger's details to the driver, even if the passenger has caused damage to the driver or his vehicle. The driver must use the route Uber London instructs at the risk of a deduction from wages otherwise. For completed trips, Uber London will pay a commission of 80% of the fare, which Uber London will calculate according to a formula only known to Uber. Payment will be made for completed trips, even where the passenger does not pay Uber. However, if the passenger cancels after the driver has accepted a trip, the driver has no recourse against the passenger. Drivers are subject to a disciplinary process, breach of which will lead to remedial action or termination, and offences include poor English, poor driving, and inappropriate conversation with passengers. Likewise, remedial action, potentially leading to termination, will be taken against any driver who receives insufficiently good passenger ratings. Uber London will maintain all relevant records, and Uber London will determine passenger complaints, generally without reference to the driver, and may make deductions from drivers' wages in its absolute discretion. Lady, my lords, these terms are not randomly selected, of course. As the court now knows, they are the sum of all the main obligations in this case, either as agreed between the parties or as found by the tribunal. Secondly, to adopt Lord Templeman's metaphor from Street and Mountford, they are the hallmarks of the Limb B worker relationship, whereby an individual undertakes to perform personally any work or services for another party. The hallmarks of what Mr. Justice Elias, as he then was, approved by this court in the Clyde & Co case, referred to as a dependent work relationship. My lady, my lords, any employment lawyer, any employment tribunal would immediately recognise, as this tribunal did, that a contract with these obligations is a worker contract. Now, if you'll bear with me, imagine that 2 years go by and it becomes apparent to Uber London that it can save millions of pounds a year in holiday pay alone if it can remove its drivers from the scope of worker statutory protections. The CEO of Uber London confers with a team of lawyers and asks them to explore what can be done, but with the caveat that all of the above features of the relationship must remain in place. A week later, the lawyers return and inform the CEO that they have devised a workaround. They will restructure the contractual relationship as one of agency, whereby the driver contracts directly each time with the passenger. They assure the CEO that none of the prior obligations has changed, and they run through some of the new terms. Uber London will no longer be a party to the contract, which will instead be with Uber BV. Uber will be recharacterised as not providing transportation services. Drivers will be called customers and will be assumed to be limited companies employing drivers. The commission of 80% paid to the driver will be renamed a commission of 20% paid to Uber. The obligations to accept and not to cancel trips and the disciplinary process will be removed from the contract and the relevant obligations placed instead within a confirmation and cancellation rate process and a driver offence process, respectively. Finally, terms are to be added stating that Uber exercises no control over the drivers in the performance of their work and that drivers are absolutely free to decline trips or cancel trips. The CEO is very concerned at this last suggestion, which contradicts the requirements he stipulated for the drivers to be subject to Uber London's control, in particular regarding accepting trips and cancelling trips. The lawyers assure him those obligations will remain in practice through the confirmation cancellation rate process, and at worst, the courts will ignore the no control terms in the event of a dispute. CEO has further questions. First, how can there be contracts between drivers and passengers if neither has any practical ability to enforce against the other? It is essential, the CEO says, that this not be permitted. Indeed, the driver must have no means of discovering the passenger's name or contact detail. The parties not being able to enforce legal rights against each other is a problem with the agency characterisation the lawyers concede, but the precise model they have adopted has not yet been tested in the court. And then the CEO is concerned that whatever the written agreements say, the idea of the driver contracting directly with the passenger will not go down well with the public or the regulator, perhaps, who has been making life difficult for Uber London, requiring it to be in real control of who becomes its drivers and how they perform. Will it be okay, he asks, for Uber to continue talking in public and to the regulator about Uber recruiting drivers who work for Uber London, whom Uber London controls, Uber London guaranteeing a reliable service, Uber paying its drivers? Will it be okay for Uber to continue reminding its drivers that they work for Uber? Of course, all of this, as the court knows, happened in the material period, as the tribunal found. The lawyers point out it's most unlikely that anyone, particularly the drivers or passengers, will read the written agreements. They will just tick a box to accept while downloading the app. Anyway, what Uber might say and do once the written agreements have been made may not be admissible as evidence, they suggest. Finally, Uber has tried putting similar written agreements in place in other countries, but the courts have seen through them. The CEO does not want to repeat of what has happened in France, Spain, Australia, or Florida. The lawyers reassure him that in England, the courts should stick to the written agreement. There are risks, the lawyers conclude, but after all, there's not much to lose, and Uber London decides to press ahead and gets its drivers to agree to the new written agreement in the form it is before this court when they next switch on the app. My lady and my lords, this case concerns whether the law is such that those whose work displays these hallmarks of a LIM-B dependent work relationship can be deprived of the few basic and important rights Parliament has granted them by reason of such drafting. The first submission we want to make as to that is that as a matter of applying the correct jurisprudential approach, the answer to that question is no, even before autoclaims and certainly after it. Like Professors Alan Bogg and Michael Ford QC in their article at 2272, we suggest that it is instructive in this context to consider cases from other fields of law, as to some extent my learned friend Mr. Galbraith Martin has already done. I ask you first to look at Bankway at 760. A clause providing that an initial rent of £4,680 a year would be increased on review to £25,000 was included in a tenancy agreement in order to allow the landlord to gain possession when it wanted. Because despite being an assured tenancy with security of tenure, the landlord would be able lawfully to obtain possession if, as was inevitable, the tenants fell into arrears in respect of the much higher rent. At page 764 at H, the findings of the judge are recorded at paragraph 11. Towards the bottom of that page, the judge had found as a fact that this perfectly clear agreement had been deliberately designed to have the potential for allowing the landlord to acquire possession. Over the page, he characterized, he characterized the term in the second line as a device, noting that there was nothing devious or dishonest or concealed about it. At the end of that paragraph, he concluded it was a permissible device. The relevant clause in that case had, unlike in this, been drawn specifically to the tenant's attention and was therefore certainly incorporated in the agreement they signed with the landlord. That's recorded at page 770 at paragraph 41. Moreover, the landlord intended to and did rely on that term in practice. In her judgment, my Lady Arden noted the key submissions of the respondent landlord, which echo many submissions this court heard yesterday. At page 769, paragraph 32, at C, the agreement as to rent was genuine and one which the parties were free to contract for. The £25,000 figure was within the limit provided for in the Act. At paragraph 35, at H, the landlord intended clause 8b3 to be legally binding, and accordingly the concept of pretence had no application. Over the page at 37, there was nothing in the Act to restrict the rent which the parties could agree. Moreover, the tenants were free to enter into the lease and were free on giving 14 days' notice to leave the premises. And at 39, summing up the position as the landlord saw it, the landlord had found a way through the 1988 Act. It was a matter for Parliament to alter the law if it wished to prevent what such landlords do. My lady recorded at paragraph 45 at the bottom of 771 that the landlord invoked the doctrine of freedom of contract, but noted that it is well established that legislation has interfered with that doctrine in the field of landlord and tenant. And my lady agreed at paragraph 49 on the next page, sorry, I beg your pardon, on page 773, that the judicial role is not one of social engineering, but held that it is, of course, the role of the court to give effect to the intention of Parliament as expressed in the words that it has used. And adopting that role, the issue in the case therefore became, at paragraph 51 on the same page, whether the agreed contractual term was, in substance or reality, a provision for the fixing of rent, or a provision to enable the landlord to recover possession, otherwise than in accordance with the mandatory scheme. If the latter, at H, the provision amounts to a contracting out of the statutory scheme. Now, my lady, my lords, with appropriate modifications, the claimants submit that one good way of characterising the issue in this case is to ask, are the clauses in the written documentation providing for an agency relationship in substance or reality provisions enabling Uber to act as the driver's agent so as to alter the claimant's legal relationships with Uber's passengers and requiring Uber to act as the claimant's fiduciary in that context? Or rather, provisions to enable Uber London to engage the claimants to perform work or services for it, otherwise than in accordance with the statutory scheme protecting such workers. And in answering that question, one notes importantly at paragraph 52 over the page, my lady's observation that the question whether a document is a sham or a pretence or in substance an unlawful contracting out or evasion of an act of Parliament is a pure question of fact. And as to that, my lady held that the judge had fallen into error by confining himself to the written agreement and failing to consider the surrounding circumstances, including subsequent conduct. And my lady's analysis of the material clause and the surrounding evidence at paragraphs 55 to 56 could be, we say, should be applied mutatis mutandis in this case. May I read from 55 towards the bottom of page 774? When the facts of this case are examined as a whole, it is clear that, as the judge found, clause 8b3 was merely a device. It was in reality a provision which would enable the landlord to obtain possession of the premises. As such, clause 8b3 masqueraded as a provision for an increase of rent. It was not in substance a provision for the payment of rent. It was introduced to enable the landlord to bring the assured tenancy to an end when it chose. And over the page, the last 2.5 lines of that paragraph the landlord may, as Miss Padley submitted, have intended to demand rent, but it had no genuine expectation that it would ever receive any rent under clause 8(b)(3). This case is a fortiori. Here, there is no evidence that either party intended to rely on the agency provisions, let alone has relied on them, other than as a defence to claims under the relevant statutory protection. Rather, as we shall see, it is clear that those provisions were intended not to be relied on. We take issue with Uber's submission yesterday that the Bankway case is not relevant in the present context. As you know, my lady's judgment was approved by this court in AutoCleanse at page 752 at paragraph 23, towards the very bottom of that page. Lord Clerk says, I would accept the submission made on behalf of the claimants that although the Snook case is authority for the proposition that if two parties misrepresent their true contract to a third party, the court is free to disregard the false arrangement. It is not authority for proposition that this form of misrepresentation is the only circumstance in which the court may disregard a written term which is not part of the true agreement. That can be seen in the landlord and tenant cases, and the Bankway case, and my lady's judgment in that case is cited at the end of that list of citation. And the effect of that law is summarised in appropriately broad terms by Lord Clerk at the start of the next paragraph, in similar language to that used by my lady in Bankway. Those cases were, he says, examples of the courts concluding that relevant contractual provisions interpose relevant, genuine, drawn to the attention of the parties and relied on contractual provisions were not effective to avoid a particular statutory result. The next case I would invite the court to consider is one of the tax cases, the case which it is probably fair to say moved the law on most authoritatively in this context. Ramsey and Inland Revenue is at 1001. And it concerned tax avoidance schemes which on their face negated the effect of a chargeable gain for capital gains tax purposes. The Revenue invited the House of Lords to treat those schemes as being in reality a nullity, an approach that was described at page 1024 at B by counsel for W.T. Ramsey as revolutionary. Lord Wilberforce addressed that submission, first restating familiar principles, of which for present purposes number 3, just below E, is pertinent. It is for the fact-finding commissioners to find whether a document or a transaction is genuine or a sham. In this context, to say that a document or transaction is a sham means that while professing to be one thing, it is in fact something different. And he concluded at page 1027 at B, the approach for which the Crown contends does not introduce a new principle. It would be to apply to new and sophisticated legal devices the undoubted power and duty of the court to determine their nature in law and to relate them to existing legislation. While the techniques of tax avoidance progress and are technically improved, the courts are not obliged to stand still. The claimants would say the same regarding worker rights avoidance. Having noted at D that capital gains tax was created to operate in the real world, not that of make-believe, Lord Wilberforce, referring to two United States cases, set out what he describes just above G as a process of thought which seemed to me not inappropriate for the courts in this country to follow. He cites Netsch, in which the Supreme Court had found a transaction to be a sham because it did not appreciably affect the taxpayer's beneficial interest. There was nothing of substance to be realised by him from this transaction beyond a tax deduction. And Gilbert, in which Judge Learned Hand had noted that if the taxpayer enters into a transaction that does not appreciably affect his beneficial interest, except to reduce his tax, the law will disregard it. And at that same page by B, Lord Wilberforce records that he was confirmed by such jurisprudence in his belief that, in his words, it would be an excess of judicial abstinence to withdraw from the field in such cases. He applied that process of thought to the schemes under scrutiny and concluded that in neither case was anything of commercial substance achieved by the complex and ingenious schemes. Their sole object and their sole practical effect was to avoid tax otherwise payable. As Lord Fraser put it rather bluntly at page 1038 at F, that tax loss, and it was a tax loss, was not a real loss. Their other lordships agree. Those principles were approved and clarified in the Barclays, Mercantile and Mawson case, to which my learned friend took the court earlier. Can I just return to that, starting at page 790, with a paragraph to which my learned friend has already taken the court, paragraph 32. As you've seen, the essence of the new approach is to give the statutory provisions a purposive construction to determine the nature of the transaction to which it was intended to apply, and then decide whether the actual transaction answers to the statutory description. And again, as you've seen towards the bottom of the page, the question is always whether the relevant provision of the statute upon its true construction applies to the facts as found. That is developed, and at paragraph 34, 791, just below C, having referred to Lord Wilberforce's reference to the real world, a good deal of intellectual effort is devoted to structuring transactions in a form which will have the same or nearly the same economic effect as a taxable transaction, but which it is hoped will fall outside the terms of the taxing statute. It is characteristic of these composite transactions that they will include elements which have been inserted without any business or commercial purpose that are intended to have the effect of removing the transaction from the scope of the charge. And that was considered, no doubt rightly, to present problems for tax laws. And at 792, within paragraph 36, towards the top of the page, the House of Lords cites with approval the statement of Permanent Judge Ribeiro in the Hong Kong Arrowturn Assets case. Equally applicable, we say, in this case. The ultimate question is whether the relevant statutory provisions, construed purposively, were intended to apply to the transaction viewed realistically. As my Lord Reid alluded to, those same principles were examined and amplified by this court in the UBS case, which the court now has, and to which has also been referred. Can I just take the court to a couple of other paragraphs in that case? I don't have the electronic bundle numbering, but I believe, doing some maths, that 75 is where I want to begin. In any event, paragraph 62.
Yes, that's the right page.
I'm grateful, my lord. my lord, with whom the rest of the court agrees, talks of the significance of the Ramsey case, and in the third sentence notes that secondly, and equally significant, that case established that the analysis of the facts depended on that purposive construction of the statute. And moving down, that needs to focus on just at D, the commercial reality, and just below D, the transaction as a whole. And then at paragraph 67, my lord picked up that reference to the word reality. That's at page 77, right at the top, and said this: references to reality should not be misunderstood. In the first place, the approach described in Berkeley's Mercantile and the earlier cases has nothing to do with the concept of a sham as explained in Snook. On the contrary, as Lord Stane observed in the McGuckin case, tax avoidance is the spur to executing genuine documents and entering into genuine arrangements. And that leads, my lord, to go on in paragraph 68, as the court has already had its attention drawn, to make the point in the second sentence, that the point is that the facts must be analysed in the light of the statutory provision being applied. That is to say, what facts are relevant depends on whether they are material to the application of the statute. And in this case, the relevant fact is whether the overall outcome of the features of the relationship between the parties is whether the claimants undertook to provide work or services to Uber London. A final point that emerges from the tax cases, but it's been adopted in the employment cases, I don't believe to be controversial in this case. We included in the bundle that was sent this morning the case of Furness and Dawson, and again hoping the arithmetic is correct, at page 55, the last page of that case. Lord Brightman, just above C, says this: for my part, I have no doubt that the correct approach in this type of case, where inferences have to be drawn, is for the commissioners, that's to say the fact-finding tribunal, to determine or infer from their findings of primary fact the further fact whether there was a single composite transaction, in the sense in which I've used that expression, and whether that transaction contained steps which were inserted without any commercial or business purpose apart from a tax advantage, and for the appellate court to interfere with that inference of fact only in a case where it is insupportable on the basis of the primary facts found. And as I say, that has been adopted ever since in the field of employment law. And just to take you to one example, at page 1779, in the Court of Appeal case of Nethermere, you see at C, this means, as explained by Lord Brightman and Furness, not merely that the primary facts as found by the fact-finding tribunal must stand, but also the inferences of fact drawn by that tribunal from the primary facts can only be interfered with by an appellate court if they are insupportable on the basis of the primary facts so found. And of course, in this case, the inference of fact as to whether the claimants were personally working for Uber is just such an inference of fact. Those same principles were applied with perhaps added force by this court in auto claims, in the concept of the Linnaeus definition, namely someone who works under a contract of employment. At page 756, as you've seen at least once, Lord Clark, relying on the critical difference between a case in which employment rights are claimed and an ordinary commercial dispute, namely that organisations offering work tend to dictate the written terms that the other party has to accept. we do not understand the supposed possible inconsistency that Uber suggested might be there between paragraphs 34 and 35 on page 757. The last sentence of the quote of Lord Justice Aitkins within paragraph 34 reads, "In practice, in this area of the law, it may be more common for a court or tribunal to have to investigate allegations that the written contract does not represent the actual terms agreed, and the court or tribunal must be realistic and worldly wise when it does so." That, we say, leads naturally to 35, as indeed the first word of 35 would indicate. So, and Lord Clark sets out at paragraph 35 that two things follow from that. First, as you've seen, that the relative bargaining power of the parties must be taken into account in deciding whether the terms of any written agreement represent what was truly agreed. And as to that, as was noted by the EAT, if you will go for a moment to page 350, at paragraph 98, recognition of the imbalance of power between the parties in the employment context has informed the introduction of the statutory rights, such as minimum wage and working time protections, that the claimants seek to exercise in this case. See, for example, a Lord's observation in the Unison case that you were taken to yesterday, that I won't read out, but which follows. Going back to autoclaims, to page 756, the second thing that follows, as noted within paragraph 35, is that the true agreement may have to be gleaned from all the circumstances of the case of which the written agreement is only a part. As has been said, this is an important point. As in the landlord and tenant cases like Bankway, and contrary to Uber's case, in making its assessment, the tribunal is required to look at all relevant evidence. And that evidence includes at least the following: the terms of the written agreement as a whole, not just the ones on which the employer relies. The circumstances in which the agreement was entered into, if that is the right way to characterize a tip while signing on to an app. And the reality of the arrangement between the parties is evidenced in Australia by their subsequent conduct. Any or all of those factors may demonstrate the artificiality of the terms on which the employer does rely. If, on the other hand, as Uber proposes, you take the written documents as the starting point and ask only whether their terms are fictitious or a sham, you may well, as Lord Reid suggested yesterday, not get to the right answer. That is the correct legal approach to this case, and it is the one that the tribunal adopted. And before the short adjournment, can I just make two short but important points about the ambit of that evidence, that relevant evidence in this case. First, as regards the terms of the written agreement as a whole, Uber is wrong to say, and it has said so repeatedly, including yesterday, that the tribunal disregarded the entire written agreements as fictitious. On the contrary, the tribunal supported its conclusion that the claimants were Limb B workers by reference in part to several of those written terms. What the tribunal did find, and the relevant part of their reasons is at page 393, at the end of paragraph 91, was that the characterization of Uber acting as agent for the claimants who were making contracts directly with passengers was a pure fiction which bears no relation to the real dealings and relationships between the parties. And what might be described as Uber's sleight of hand in this regard is insidious, because Uber moves from the false premise that the tribunal dismissed the whole agreement as a fiction, then to attack many of the features of the relationship between the parties which the tribunal found constituted features of a LIMB worker relationship as being consistent with the written agreements, which of course they are. That is simply to knock down an Aunt Sally. Secondly, and relatedly, the reality of the arrangements between the parties does include the requirements of the regulatory scheme. And we go a little further, I think, than Mr. Galbraith-Martin did by reference to Gillam at page 1490. We say that Uber makes a bad point by reference to paragraph 18. This is the case about the district judge. At 18, Lady Hale is not saying that one must ignore the requirements of the statute in determining the actual obligations of the parties between themselves. On the contrary, between H and J, as she points out, was the situation in that case. It may be that most or all of the essential components of the relationship are derived from statute. And we have never really understood Uber's point on this. If the regulatory regime requires Uber London to impose certain obligations on its drivers, then those obligations are imposed by Uber London on its drivers and are nonetheless obligations by reason of the fact that Uber London had no choice but to impose them because of the regulatory regime. My Lord, if that's a convenient moment, I propose to stop there.
Yes,
Could I
thank you
just
very
ask-
much, Mr. Siegel.
Could I just ask a quick question?
Of course, my lady.
If it's permitted by the President before we rise, just swiftly, in case you want to think about it, would it be a better explanation of auto-cleanse to acknowledge the role being played by the statutory regime? I think we could think, perfectly happy to reply.
I'm the only reason I pause is that my lady is obviously making a comparison between that approach and another approach, which I take my lady to have inferred was the approach I was advocating, but I'm not sure that I would assent to the proposition that the approach I was advocating was particularly different from the approach my lady's just said might be better. So I suppose my proper answer is that is the proper approach, and if I have indicated that the approach was something less than that, then mea culpa.
Very well. We'll adjourn now and sit again at 2 o'clock.